Welcome back to Hey Kentucky. Now, since Steve is joining me tonight, we have special graphics, and it's time to play Ask a Lawyer. That was just for you.
I like that.
We did that just for you. People have questions for an attorney. Steve's going to answer them. Let's get started. We got this one in from Twitter. What's the worst that can happen to me if I ignore a notice for jury duty? Good question.
You can be held in contempt and arrested. That's
Does
the
that
worst.
happen?
No, the question is, what's the worst? The worst is you can be held in
All right,
contempt
so
and arrested.
practically
speaking, nothing.
Nothing.
No.
Now, does that change? Is it different, say, in Lexington than maybe in a small county?
Possibly, because it's up to the judge. The judge has the discretion to do it. Oftentimes, when I try a case, I will ask that, we'll get the number of jurors who've responded, and then I'll ask the judge to send an additional letter out threatening them with contempt.
Have you ever seen anybody charged?
No.
Well, there you go.
No.
So, next, when I share something on Facebook or social media, is there any privacy with what I share, even if it's just to my friends?
No. Once you put it online, it's online.
All right, so let's say somebody puts something on there that's got information. If someone then takes that information and does something with it, do you have any recourse?
Well, it depends on what they do. If they commit a crime with it, they steal your, identity theft or things like that, then that's an additional crime. But you don't have any protection in regard to what you put in public media.
Some people think that if their site is private and they've only allowed their friends to do it, that it only keeps their friends are the only ones that can use that information. That's false.
That's false.
So It doesn't matter what your privacy settings are.
It doesn't matter if you've got privacy settings and only because you're publishing it to hundreds of people theoretically.
And at that point, they do with
Correct.
it what they do. So the short answer is don't post anything on social media you wouldn't want people to know.
Correct. And don't post anything that you want to keep an interest in.
I think that's exactly right. Next, this isn't me, but I was involved in a bar fight, says the writer, but I didn't start it. What are my rights and will I be charged?
Well, it's possible you can be charged, and your rights are you have the right to self-defense.
Okay.
So anytime you have a reasonable fear that you are about to be assaulted or harmed, you have the right to use reasonable self-defense, which is proportionate to what you fear is going to happen to you.
So there is a difference in a fight scenario as to who started it. Is that, but does start it mean who threw the first punch?
No, it does not. You
Okay.
do not have to wait to get hit.
Okay.
You can throw the first punch if you have a reasonable belief that someone's going to hit you.
Okay, so as a practical matter, it's the standard of a reasonable person, not your standard.
Correct. Well, what I would say is this, too. If you're in a bar and you think you're about to get in a fight, either leave or throw the first punch. But don't wait. Don't wait.
That's great legal advice.
No.
Either leave or throw the first
don't
punch.
stand around mouthing.
Don't talk.
No.
Don't do what I would do.
You either punch or you leave.
Or you get out. All right, next. This is a serious one because this is in the news all the time. What is the standard when a law enforcement officer is charged in the death of a civilian? We hear this all the time. What is it that makes a law enforcement officer be charged?
Well, again, obviously it's the death of a civilian, so they've charged them with a homicide, all right? And let's just say it's murder, all right? There are no differing standards between law enforcement and a citizen, all right? The self-defense law applies to law enforcement just like it does to a normal person.
But now so we've had these situations. Some officers are charged, some aren't. That initial decision is what?
Well, it's made by either the prosecutor,
Yes.
who can make a decision that they were acting reasonably in self-defense,
Okay.
or it can be made by the grand jury. Now, oftentimes what will happen is a prosecutor will not want to accept the political fallout for not charging them, so they'll present the case to the grand jury and let the grand jury not indict. Now, the difference is when they present a case to a grand jury when a cop shoots someone, then they present all kinds of information, including exculpatory information.
Which they don't always do.
If you shoot somebody, they just put before the grand jury, you shot somebody and they died. I mean, that is the difference.
So the difference beyond the political stuff, the difference between when we see one officer charged and another officer charged is really whether or not the self-defense is there. Is that what you believe?
If self-defense applies, and the other they have a slightly stronger protections in that if an officer tells you, you have to obey their orders.
Yes.
So if they tell you to stop or get down and you don't, they have an argument that they're acting reasonably by defending themselves because you did not.
But it all comes down to self-defense.
It all comes down to self-defense, and the law is the same for a law enforcement officer as it is to anybody else.
There you go. You have learned on Ask Laurie. We'll do this again. If you have questions, go ahead and send them to us.